2018 likely a big year for employment law in Colorado. We're closing in on the end of the first quarter of 2018, which means the Colorado legislature is a little over halfway through its legislative session and the state courts are in full swing for the rest of the year. Most employment law watchers have their eyes on the labor law appeals at SCOTUS, but Colorado has a lot on the schedule for labor and employment law as well. Colorado legislative employment law activity. Colorado is among several states where conservative lawmakers pursued bills seeking to undermine labor union presence and minimum wage protections. Immigration status. The House is currently perusing a bill to extend legal work status to undocumented workers in the state that meet specific requirements proving the workers' history in this country has been positive. FMLA insurance. Another House bill seeks to introduce an FMLA insurance program for wages. Given the challenges created by the way the Colorado legislature designed its state FMLA statute to sit on top of the federal FMLA, passage of this program could create new complications in the state's family and medical leave law. Non-compete exception for physicians. Physicians are generally better protected from overreaching non-compete agreements under Colorado law. However, they can be liable for damages caused by terminating the agreement. This Senate bill would create an exemption to damages for physicians to continue to provide care to patients with rare conditions. Minimum wage waiver. In one of the more ridiculous legislative offerings, a House representative offered a bill that would, 1. Require employers to notify job applicants of the right to negotiate minimum wage, and 2. To negotiate a minimum wage less than the Colorado Constitution requires. The House committee quickly laughed at and destroyed this awful legislation. Right to work bill. Not to limit their terribleness to just one bill, House Republicans introduced a bill to make Colorado a right to work state that allows workers to decline representation or membership in a union as a condition of employment. Gig workers are contractors. The Senate passed a bill last week that makes workers who find part-time jobs through online job marketplaces are contractors rather than employees. While many of these workers likely are contractors, this bill seems more of a first step in expanding state law to make all workers in the gig economy contractors, surely a move backed by larger players in the field like Uber and Lyft, who have been hit with misclassification lawsuits around the country. Colorado courts employment law activity. If March is any indication how the Colorado Supreme Court feels about employment law, it's not a good sign for employees. This month, Colorado's highest court ruled against employee rights on small but important issues. Teacher right to hearing before placement on unpaid leave overturned. The Colorado Supreme Court overturned an appeal on public school teacher rights to a hearing before being placed on unpaid leave. Statute of limitations on unpaid wage claims upon termination under the Colorado Wage Claim Act. In a case with broader implications, the Colorado Supreme Court also interpreted the Colorado Wage Claim Act, CWCA, to reduce the limitations period for claims of wages due upon termination. In Hernandez v. Ray Domenico Farms, the court resolved the ambiguity over how far back an employee could seek unpaid wages due upon termination. The CWCA sets a 2-year limitations period, extended to 3 if the violation is willful, for claims brought under the statute. Among the statutory claims is the right to be paid all due and unpaid wages upon termination. The plaintiffs in this case, along with some Colorado courts, argued the limitations period reset with each instance of unpaid wages, so the unpaid wages owed could extend as far back as the beginning of the employment relationship. What should we expect for the rest of 2018?